Etie for my minda muna masi and fambra your channel you message set notification button or turning on now subscribe to the any update to be on Sabeka no ashe ama bibia aye kama a branch of mangi break near kutie in same kakra ekos.
When you brought 1992 constitution, they boycotted, but they contributed to it. They went to court. Go and look at the Ghana Bar Association law report. Don't go there, President Mahama. Don't try. Let's see what the Bar Association said. Okay. 1. Revocation of suspension. The Ghana Bar Association calls for the immediate revocation of the suspension of the Chief Justice as it considers the suspension to be unconstitutional, considering the fact that the President, who is not a judge or a judicial officer, exercises discretion to suspend the Chief Justice under Article 14610 of the 1992 Constitution in the absence of a published constitutional instrument, statutory instrument, or regulations governing the exercise of his said discretion as required by Article 296 of the Constitution. The Ghana Bar Association hereby also calls for the immediate enactment of a clear and comprehensive regulation relating to the matters under Article 146 of the Constitution, the Republic of Ghana, etc., etc. In addition, calls upon President of the Republic of Ghana to immediately release the full decision establishing a prima facie case against the Chief Justice consistent with established precedent. This disclosure is necessary to ensure that the process is conducted in accordance with the principles of transparency and fairness. Now, I'd like to expand on this a little bit. The Bar Association is saying, and I've seen Dr. Kwesi Prempe's document, just came to me as I was going to the studio. Kwesi Prempe seems to be arguing against it, and I'm completely confused. Now, on the first one, where they are talking about regulations, people are going to Dateba, but I think that Dateba must be read well. Dateba says that where the person is not a judicial officer, he has to publish regulations, but when he's a judicial officer, you can't ask him to publish regulations to exercise his discretion because he's already a judge, he's a judicial officer. That's what Dr. Ban says. Dr. Ban didn't say that anybody who exercises discretion cannot publish anything. You are not a judicial officer, Mr. President, so you have to publish the regulations. Forget about that, that's very legalist and that's technical. But let's come to the basic one. You say that the Council of State found something, extension is saying that show us the thing. Okay, I'll come to this in a minute. It says, show us the thing. What did the Council of State see that they decided that a prima facie case has been made? Because Chief Justice, he is not elected by NDC people or elected by MPP people. He is a Chief Justice appointed by whoever is President of Ghana. Now, in exercising his authority to appoint the Chief Justice, His Excellency the President is not performing a governance function. He's performing a state function. Political scientists, come and let's talk. State and government. The difference between state and government. Monocephalous executive, bicephalous executive. In bicephalous executive, the head of state is different from the head of government. So if you are in England, it is Her Majesty the Queen that appoints the Chief Justice, not the Prime Minister. The monocephalous executive inside the president's body, half of it is state, half of it is government. Sometimes he's performing a state function. When President Mahama went to the Ghana Military Academy and was nicely clad in naval wear, he was performing a state function. The commissioning of officers to the Ghana Armed Forces is a state function. It's not a government function. When President Mahama goes to launch Mahama Cares, it's a government function. It's an NDC government function. It's not a state function. When President Mahama nominates somebody for the position of Chief Justice, it is a state function. It's not a government function. So the Chief Justice is a Chief Justice of the state. That is why on Independence Day, you will see the Chief Justice, they will say that the arrival, if you are watching GBC, the arrival of the dignitaries, the Lord Chief Justice, Justice Tokonu, Justice Emi Yabua, Justice Philip Archer, Justice Aban, whoever it is, they climb up the dais and they sit there. They sit near the president. They are performing a state function. When it's an NDC rally, Justice Tokonu will not be there. When it's an NDC rally, Dr. Maniboma will be there. He's NDC Minister for Defense. He will be there. So we have to understand this principle. That's what the Bar Association is saying. That, Mr. President, you cannot say that you found something against the Chief Justice and it's a secret. So only you know, only you and the Council of State know. This era of social media, of plural media, we cannot accept that. Come and show us the details. What happened? What happened? Come and show us. I'll come to Justice Bafumoni in a minute, but let me look at this. Justice Sh0cks, the Deputy Attorney General, has been very ballistic. He called the Bar Association document reckless. Justice Sh0cks, he says that the Bar Association document is reckless because today he's Deputy Attorney General. After Akufo-Addo gave him scholarship to go, and he's a brilliant guy. Akufo-Addo gave him scholarship to go and learn. He comes back and he's a Deputy Attorney General. We all applauded it. And then he says the Bar Association statement is reckless. Okay, how did the Bar Association put their statement together? This is the second statement the Bar has issued. They issued one last week. The Bar Association knew that they had their mid-year bar conference. So it appears they have two conferences. One is the big one in October also, and then they have this one, the mid-year one. Every member, all the 6,000 members of the Ghana Bar Association are invited to this conference. They went to the conference. 90% of those who attended in person voted for the statement that has been published. Sh0cks says that it is a reckless document. Listen to the PR of the Ghana Bar Association. He says, I don't think it's fair to say decisions have been imposed on us. This is our position. Others may disagree, but it is the position of the bar as adopted by members at the mid-year conference. Xavier Kuje, PRO of the Ghana Bar Association. That's him. That's him. This is Mr. Xavier Kuje. Yeah, I like his tie. This is Mr. Xavier Kuje. Xavier Kuje says that I don't think it's fair to say decisions have been imposed. Now, Sh0cks goes about telling the Bar Association that they don't have the capacity to put the statement together, that the thing has been imposed on them by Diana Sunaba Dapa. I mean, that is so insulting for the Deputy Attorney General to say that the leadership of the bar, all of them are his seniors at the bar. Not one is Sh0cks a contemporary. Even me, when I was in law school, Sh0cks was not there. Even me. And the leadership of the bar says that the decision was imposed by Diana Sunabadapa, the former Deputy Attorney General, the very articulate Diana. I heard her on Asempa. Wow, beautiful. Diana really knows her law. Justice Sh0cks, what is, you see, we have to think about Ghana. Sh0cks can hold that opinion, but he must hold it in the chambers of the Attorney General's office. Discuss with Dominic Aini and Edwin Tamaklo however they want to do it. They can issue some statement or something. But to come out and say that the Bar Association statement is reckless, is that how Sh0cks is going to start the 4 years? This is how he's starting? That he's calling the Bar Association. Sh0cks should stop that. Go and tell Sh0cks that he should stop that. We are not small boys in this country at all. As for power, we have seen it. So that power is means nothing. We were here when Rollins 2000. I was with him. If you like, I'll show you the video. I have seen Rollins in the castle. I have seen it. I have seen Kufuor. We have seen it, sir. So he shouldn't think that the Attorney General's office is anything, something. No. When Jogati was Deputy Attorney General, every evening I was with him in his office. So we have seen it. It's not anything, but it's something. But it's not anything, but it is also something. We congratulate him for being Deputy Attorney. I think he deserves it. And I think he spoke very well at his vetting. Sh0cks really distinguished himself. And the people he teaches, they all tell us that Sh0cks is a great lecturer. He should stop that. He shouldn't let the politics get into his head or the NDC thing get into his head and start calling Bar Association reckless. And I'm happy that Xavier came back to say that I don't think it's fair. So to say any decision has been imposed on us, this is our position. Others may disagree, but it is the position of the Ghana Bar Association adopted by the members at the mid-year conference. A position voted upon. They didn't just write it to. They voted upon it, made over 90% voted in favor of the statement. So Sh0cks, get it right, get it right. But we are yet to see what will happen. Because next week, there is a court case that we are going to be dealing with. We are going to be there to cover the court case next week of Asafwa, MP Asafwa, who is asking for the court to make a determination that the place an injunction on the process against the Chief Justice, because Asafwa is alleging that His Excellency the President did not send the document to Madam. Okay, he sent it through another process, not through the court process anyway. But he's also making another allegation that whilst the pendency of the matter, during the pendency of the matter, the government and the president cannot go on with the process, the pendency of the injunction. That once an injunction is pending before a court, they cannot go on with the process. Now, there is sufficient legal authority to back that thinking. document is filed in court and an injunction is filed, and you are a party to it, and you see that the injunction is filed, the injunction process has been served upon you, you cannot progress with it. There are many authorities, but tonight, viewers, I'd like to show you the foremost authority in this matter, and you will marvel who the judge is. Titled The Republic versus Bank of Ghana and 5 others. Ex parte Benjamin Dufour. It was this case that got me to know that my great uncle Kwabena Dufour is called Benjamin. Beautiful. Today I'm going to tease you that they say you are called Benjamin, you don't tell us. Every day you say you are Kwabena Dufour, you are Benjamin, whether we like it or not, you are Benjamin. Listen to this. Look at Justice Bafuboni, the acting Chief Justice. He gave this ruling. Justice Bafuboni, see what he said. When a court is seized with jurisdiction to hear a matter, nothing should be done to usurp the judicial power that has been vested in the courts by the Constitution of Ghana. In effect, the state of affairs before the courts was seized with the matter must be preserved until the court delivers its judgment. This is so whether or not the court has granted an order to preserve the status quo or not. A party to the proceedings will be in contempt if he engages in an act subsequent to the filing of the case, which will have had the effect of interfering with the fair trial of the case or undermine the administration of justice. Justice Bafuboni, the acting Chief Justice. It will be quoted to him. His Lordship will be told that, my Lord, this was your ruling in the Bank of Republic versus Bank of Ghana, exported before Benjamin. He clarifies here. Justice Bafuboni, my good friend Paul Bafuboni, is a wonderful man. Absolutely incredible. I saw a video of him. He was dancing in the church. He loves the Lord. He's a great guy. Justice Bafuboni, how are you? Good to see you. We share the same name, Paul, and I'm taking from your greatness. But this is what you said, my Lord. This is what you said. You said, where a party, that is the President and the Council of State, knowing that a case is sub judice, they say, engages in an act or omission which tends to prejudice or interfere with the fair trial of the case despite the absence of an order of the court. The party is held. It says, even if there's no order from the court, the fact that the court is seized with the matter, is the court not seized with the application for injunction? The court is seized with it. He talks about something subsequent. Here it is, I'll show you. Where is it? He says that a party to the proceedings will be in contempt if he engages in an act, subsequent to the filing of the case. That is anything that happened subsequent after the case was filed. After Asifwa filed his case, then President Mahama sent the documents to Tokonu, and then they proceeded to go and do prima facie case. Justice Paul Bafuboni says the President, the Council of State, anybody who participated should be held in contempt of the courts. This is what the Bar Association is saying. I mean, people are in a hurry. Dr. Kwesi Prempeh, please, so we respect you. Please. Dr. Kwesi Prempeh, we beg you. We beg you. We know that you are an American trained jury. This is the law. Bafuboni is the one who said it. Many people said it, but on this occasion, God has given us a good example. When we're looking for the thing today, producer called me and said, Chairman, we have something super. I said, what is it? Did you get authority for that? He said, I got it. I said, yes, they said, no, but you should hear who did it. I said, who is it? Justice Aban? Is it that Aban? He said, no, it's Bafuboni. I said, hey, Bafuboni, bring it. You see, paper and pen, they don't lie. History. That's the case of the Republic versus Bank of Ghana, ex parte Benjamin Dufour. That's what Bafuboni said. And that's what the Bar Association is saying. That the government and the President and the Council of State, they are in contempt of the process. And this is a matter that people cannot understand. That, well, some say the Bar statement was too strong. Maybe.
CI or a statutory instrument before that is done. Why should anybody have issue with it? That is the position the members have taken. We may be wrong, we may be right. We all have views. And if you attend a meeting, the very fact that you have your personal views and various people have expressed various views, that doesn't mean that the meeting will not come to a certain decision. Once the meeting comes to a decision, it becomes a decision of the meeting. In that wise, you cannot be pushing your personal views any longer. So I don't think that it's fair to say that decisions have been imposed on us and going to the extent of mentioning the former Attorney General's name, the Deputy Attorney General's name. I was at the meeting, I didn't see my learned good friend Eddie there. You may have heard things, but I think that sometimes it is the best for you to have information first hand before you comment. So for us, this is our position. They may disagree with it, but this is the position of the bar as taken by members at the media conference.
So it's safe to say that you're just voicing your opinions and it may not be founded in law. Is that the case? Can you point to one constitutional breach when it comes to the procedure the president went through with the removal of the Chief Justice? Just one.
I think that is what we have said in the statement, that to the members present at that meeting and who put together this resolution or who resolved on this are saying that as far as the discretion of appointing the Chief Justice is concerned, the president ought to have done that under a published regulation as required by Article 296. Let us not forget that the Supreme Court is not bound by this decision. The fact that Mr. Fran's case said not in all cases that this must be done. Nobody is too sure whether the Supreme Court in the future can say that in the president exercising a discretion of this nature, he shouldn't have done that under a published regulation.
Now, I want to find out from you, as a bar, would you be going to court to challenge this? Are we going to see action?
That's a possibility, because once it's about a constitution or law, that's a possibility.
A possibility you'll be exploring how soon?
Because going forward, there must be clear guidelines as to how these things ought to be done. So that's a possibility, to have the courts to interpret that for us.
Stay with me, Xavier. I'll come to you for your final words, but let me get a direct response from Edichi. The Ghana Bar is threatening to go to court. Your response?
President Mahama's association with the Ghana Bar Association relating to them going to court and the decision that he is taking, it's not going to be new. Under the bar precedent, when Amadachi, who later became the Supreme Court judge, when President Mahama appointed or nominated for appointment two Supreme Court judges, his lawsuit justice Gabriel Palmer and Justice Mahama, the Ghana Bar Association went to the Supreme Court to challenge the procedure President Mahama has adopted in the appointment of those judges. At the end, the Supreme Court wrongly the bar lost against him. So the bar can try again. They don't need a resolution. What they strongly believe in what they claim and want to discuss. They have the benefit of going to court rather than hiding behind the resolution. But the bar that kept quiet because we are supposed to be in prison custody. The bar that already was kept quiet. What happens when the people of country are country?
Okay. But the bar is speaking. Look at Article 146, Section 11, EDG. If you allow me to come in at this point, the bar is speaking now. And if you look at Article 146 of the 1992 Constitution, Section 11 says the President may at any time revoke a suspension under this article. As Director of Legal for the NDC, would you advise the President to revoke the